Welcome to Law Centre NI's video guide to the Employment Tribunal. Each year, thousands of people make a claim to the Tribunal in the hope of resolving their workplace dispute. This video is intended to help you understand the key elements in bringing a claim to the Employment Tribunal and what to expect on the day. Today's video will follow Anne's journey to submitting her claim at the Employment Tribunal. You can watch this video to learn more about the Employment Tribunal process. The tribunal process can be lengthy, time-consuming and stressful. You may want to consider the following before beginning your claim. What are you looking to achieve, and what does a successful outcome look like to you? The process is formal, and without legal representation, it will require you to undertake public speaking, prepare documents, and face the challenge of being cross-examined. Are there any alternatives to legal proceedings? For example, would you be better suited to mediation or arbitration? Additionally, most tribunal claims must be taken within 3 months of the incident, dispute, or termination occurring, and this time limit can only be extended in exceptional circumstances. If you are unsure about what to do next, speak to an advisor. If you are a member of a trade union, you could be entitled to free legal advice. Additionally, if you have house insurance, the small print of your policy may include legal expenses insurance that may be able to help with the cost of a solicitor. Let's see what Anne learns about early conciliation when she calls the Labour Relations Agency to find out more.
Hello, I have been unfairly dismissed by my employer and I'm not sure what to do next. Can you please help?
If you would like to continue and submit your claim to the tribunal, the first step is to complete a process known as early conciliation with the Labour Relations Agency.
I'm sorry, but I'm not sure what that actually means.
During the early conciliation process, an LRA conciliation officer will work with both parties to come to a resolution without the need, cost, time or stress of continuing your claim at the tribunal. The officer is not there to make a decision or judgment, but will instead facilitate negotiations. Coming to an agreement through early conciliation has advantages. For example, you can negotiate an employer reference during early conciliation, which is something you're unable to do in the tribunal, even if you win.
And do I have to take part in early conciliation?
No. Early conciliation is a voluntary step. You do not have to take part in the negotiations. However, you must show that you have considered it and received your early conciliation certificate before you can continue your claim at the tribunal. If you think there is no chance of a successful negotiation with your employer, you can ask for a certificate to prepare tribunal proceedings.
It is important to remember that if you settle your claim during early conciliation, it will be legally binding. If you have started your tribunal proceedings, the conciliation officer will notify the tribunal and your claim will then be removed from tribunal proceedings as it has now been settled. If you are not able to come to an agreement, you should ask for your early conciliation certificate, as you will need this to commence a claim in the tribunal. Anne is not sure about what she needs to do next. Let's join her now.
I've not reached an agreement with my employer. During early conciliation, what do I do next?
If you do not reach an agreement during early conciliation, the next step is to complete your tribunal ET1 claim form. This form sets out the details of your claim, contact information, and your early conciliation certificate number. It should contain a brief statement summarising the relevant facts and any matters that you would like the tribunal to consider during your hearing.
What does the respondent mean on the claim form?
The respondent is the person that your claim is against, so in this case it will be your employer.
What about compensation or monies owed? Do I need to put that on the claim form?
You may be asked to prepare this more formally in a schedule of loss at a later date.
Can I leave parts of the form blank if I'm not sure what to put?
You should be careful about leaving questions blank, as forms can be rejected if they are missing certain information or if the names of the parties don't match your early conciliation certificate.
If I get something wrong, will I automatically lose my case?
If you are missing information or you have completed something incorrectly and it is rejected by the tribunal, you can apply for a reconsideration if the mistake can be rectified or if the decision to reject your claim was wrong. You have 14 days from the date the notice of rejection was sent to you. However, it is important to take your time when drafting your claim form in the first place, as it can be difficult to amend it once it has been submitted to the tribunal. It is very important that the title of the employer and the address you give to the LRA are the same as those you give on the tribunal claim form.
Who do I send the ET1 to when I have completed it?
The ET1 can be sent to the tribunal via email or post. You can find the contact details on the claim form or on the tribunal website.
Once you have completed your ET1 form and sent it to the tribunal, they will forward it to the respondent. If the respondent disagrees with your claim, they will prepare a document called an ET3 form, which outlines their defence. They have 28 days to complete this form. Sometimes there is a delay in processing the papers, so any response could be delayed by a few weeks. You will receive a copy of it after it has been submitted to the tribunal. After the ET1 and ET3 have been considered, the parties will receive a date from the tribunal officer for a case management preliminary hearing. This is an opportunity for the employment judge to identify the issues in the case and to agree on a timetable for the next steps to take place, such as a date for exchanging evidence, documents, and providing witness statements. The employment judge might also try to clarify the legal and factual issues in your case, or set a date for when this is to be agreed in writing between both parties. This statement is written in neutral terms and covers the factual and basic legal arguments as agreed by both parties that will arise in the claim. You may be asked to produce a version of this statement before the tribunal preliminary hearing. Let's ask the legal officer some more questions about preparing our documents for the tribunal.
What is evidence?
Evidence can include emails, letters, WhatsApp messages, pictures, staff handbooks, a contract of employment, or other documents that help strengthen your claim. You should also provide the respondent with any documentation relating to your financial loss, and this will include details of searches by you for alternative employment. It is important that you keep these records even if they are unsuccessful applications.
What if I don't have a document, but my employer or the respondent does?
If you believe that the respondent has documents relating to your claim, you can send it a notice of discovery to request the information from it.
I don't fully understand what the respondent was trying to say in their ET3 form, and I want to make sure I'm prepared for all arguments. Is there anything I can do?
If you're unsure about some of the issues and statements that have arisen from the ET3 form, you can ask the respondent to clarify these statements through a notice of additional information.
If I can request those, does that mean the other party can as well?
Yes, it is important to be aware that the respondent can send you a notice of discovery and a notice of additional information too, and you must reply.
Am I allowed to bring a witness to the hearing?
Yes, you're allowed to have a witness in your case. However, it is important to remember that you as the claimant will be the main witness.
What is a witness statement?
The witness statement is an important document that outlines the witness evidence in written form.
Can I have someone else give evidence on my behalf? And what happens if they refuse to come?
Yes, you can have a witness give evidence on your behalf. They will have to prepare their own written statement, and you should arrange for them to attend the hearing. If a witness is unwilling to attend the hearing, you can write to the tribunal in advance of your hearing, asking for an order requiring them to attend.
Do I have to share my witness statements with the respondent before my hearing?
Yes, you will have to exchange your evidence, including your witness statements, by the date decided at your case management preliminary hearing.
The Employment Tribunal is a legal hearing, so try to dress as smartly as you can. You shouldn't take food or drink into the tribunal hearing. Remember to turn off your mobile phone or place it on silent mode. You can address the tribunal judge as Judge, Sir, or Madam. If you are unclear about the hearing procedure, you can ask the employment judge for guidance. Let's follow Anne as she attends her tribunal hearing.
My name is Anne Dunn and I am here for my Employment Tribunal hearing. I'm not too sure where to go. Can you please help?
Hi Anne, your tribunal is at Tribunal 3 on the second floor. If you want to go upstairs and have a seat outside in the waiting area, that's no problem. I'll let them know that you've arrived and signed in. I'm done. If you'd like to follow me into the hearing room.
Remember, there are 3 members of the tribunal panel. They include the employment judge and 2 lay members. The hearing will normally start with the tribunal judge introducing the panel members, summarising the events of the hearing, and clarifying the issues that are going to be discussed.
Good afternoon, everyone. My name is Employment Judge James Wright, and I'm assisted this morning by 2 additional panel members, Jane Bell and Fionnuala Boyce. Ms. Blemming, you are appearing on behalf of the respondent, is that correct?
Yes, sir.
To clarify, I have with me a bundle of documents that have been prepared by both parties. I also have witness statements that have been prepared by both the claimant, Anne Dunn, and the respondent, Jacob Roots. In addition, the tribunal has granted a witness order compelling Mrs. Telling to give evidence in today's hearing on behalf of the claimant. Before we commence proceedings, let's just clarify the issues in dispute so that we know where we stand and what we'll be discussing in today's hearing. As I understand it, we have a claim of unfair dismissal. Is that correct?
Yes.
According to the ET3, the respondent, Mr. Roots, has outlined a defence. Can you please provide a summary of the defence for the panel?
Yes, sir. Mr. Roots is relying on the fact that evidence has been uncovered that Ms. Dunn is not fit to keep up with the technological aspect of her job and was largely unsuitable to continue in the role as she was not qualified.
Thank you for that summary. We will examine this issue further later. I also understand that there's another point relating to the early conciliation as outlined by the claimant.
Yes, there is an issue pointed out by the respondent in the ET3 that the early conciliation certificate does not match the ET1 prepared by the claimant, as the employer and name and address are incorrect. According to the Employment Tribunal rules and leading case law, unless the judge considers the issue to be a significant error in relation to name and address, it would not be in the interest of justice to reject the claim and the dispute can continue. And that is what I am asking you to do today.
In the panel's view, as both parties are present and evidence has been submitted, it is in the best interests of justice to continue with today's proceedings.
The parties can now give evidence and cross-examine each other's witnesses. In cross-examination, the respondent or their representative could ask you questions about your witness statement. Remember, both the claimant and the respondent will be the key witnesses for the dispute. So it is best to be prepared for any questions you might be asked and prepare any questions you would like to ask in advance of the hearing.
Mr. Roots, you will find a copy of your witness statement in front of you. Can you please confirm that your name and address on the front cover is correct and that the signature on the back page is yours?
Yes, they are correct, and that is my signature.
Can you confirm that you have recently viewed the document and are familiar with its contents?
Yes.
Ms. Fleming, would you like to ask the respondent any questions relating to his statement?
Thank you, Judge. Mr. Roots, can you confirm the events of the meeting on 26th July 2023 as referred to on page 4 of your witness statement?
Yes, no problem. So on the date in question.
The witness will answer questions from both parties relating to their witness statement. It is important to familiarise yourself with the contents of the witness statement before the day of the hearing. The witness is also allowed to have a copy of their statement in front of them, and you can refer to the different elements inside that you wish them to elaborate or clarify.
Thank you very much, Mr. Roots, for your account of what has happened. Ms. Blemming, do you have any more questions for the witness, or shall we continue to the claimant for any questions they may have for Mr. Roots?
No, Judge, no further questions, thank you.
In that case, it's over to you, Ms. Dunn, for your opportunity to cross-examine the witness.
Thank you, Judge. Good afternoon, Mr. Roots. Following what we have just heard, I would like to clarify a few points in relation to your witness statement and ask some questions. I understand that the key issues as outlined in your witness statement and 83 relate to the fact that I was unfit for my role and unable to keep up with the demands of the job. However, I would like to highlight the performance reviews and one-to-one evaluation meetings with the company COO regarding my performance. Can you clarify the key points as listed in my performance review for the month of June 2023, as found on page 14 of the evidence bundle?
Sorry, what page did you say?
Page 14 in the bundle.
Thank you. Yes, the main points were that.
After you have finished questioning the witness, the tribunal judge and other panel members may ask the witness to further clarify the facts.
Mr. Roots, thank you for your cooperation. If you can just wait one moment, I'm going to see if any of the panel members have a question for you.
Hi, Mr. Roots. Can I just clarify? You mentioned that the claimant's job title does not match the role and its responsibilities, and that impacted the claimant performance assessment. Can you please clarify what you mean by that?
The role has many responsibilities which are similar to that of...
Following the examination of the witness, the employment judge will then ask the witness to return to their seat as they move on to the next stage of the tribunal hearing. Again, all witnesses will be asked to take an oath or affirm with the clerk before they give their evidence. Both parties will have the opportunity to ask the witness questions, to clarify facts, and present evidence in support of their arguments. The process is repeated for all witnesses on both sides before moving on to the final part of the hearing, final submissions.
Thank you to all our witnesses today. We will now move on to the next part of today's hearing, final submissions from both parties. This is your opportunity to summarise your arguments and case to the Employment Tribunal. We will start with Ms. Blemming for the respondent.
The tribunal will adjourn to consider its decision and usually return at a later date with a written decision. A further hearing is usually not required at this stage, and the decision will include the outcome of the hearing, what compensation is owed, or what other remedy you may be entitled to if you are successful. However, in some more complex cases, the tribunal might arrange a separate remedy hearing to determine the compensation and announce their decision. It is important to be prepared for the topic of compensation. This should have been outlined in your ET1 and bundle under a schedule of loss. This sets out the compensation and losses that occurred because of dispute or conduct of the respondent.
Thank you for your patience. The other members and I have carefully and thoroughly considered the evidence and submissions and will now retire to consider our findings. This might take several months depending on the pressure of other cases. You will receive a full copy of the judgment.
You might ask yourself, what happens if I lose? If you are unsuccessful, you can appeal the decision of the tribunal to the Court of Appeal, but this can only be on a point of law. This means that even if you do not like how the tribunal has assessed the evidence in the case, this is not a basis for a legal challenge. You should also consider that if you appeal the decision to the Court of Appeal and you are unsuccessful, you could be ordered to pay substantial costs. So it is best to seek legal advice before considering an appeal. Thank you for watching Law Centre NI's video guide to the Employment Tribunal. If you are seeking employment law advice, you can find more information on our website at www.lawcentreni.org, or you can contact our specialist employment advice team on 02890 244401.